Hi and welcome to this latest immigration law update video. This is the 6th video in my series looking at the reported decisions of the Upper Tribunal for 2020, and today I'm going to look in this video at the reported decisions for June 2020. There's 5 of them, one of them concerning tax discrepancy cases, a rather complicated one on the Dublin III regulations, a very important asylum decision on the definition of a particular social group. And the last 2 look at the definition section in 117D, one in relation to qualifying children and the other one in relation to foreign criminals. I'll put the links and the citations to the cases below this video in YouTube, but I'll put the PowerPoint, so if you want the slides, I'll put those on Chamber's website. So let's crack on and look briefly at these decisions. So Ashfaq is a case concerning tax discrepancy cases. Mr. Ockleton in this case had, I think, 3 before him in his list, so gives some guidance. The Vice President looks and reviews the case law. Balajigari, of course, is the leading case. And Balajigari found that there was this procedural defect by the Secretary of State of not giving someone an opportunity to respond to an allegation of dishonesty before a decision was taken. Mr. Ockleton finds that where in cases there is a right of appeal, because in course Balajigari, they were judicial reviews, where there's a right of appeal, that cures the defect because a judge can consider all matters and make their own decision. And that really comes to the same conclusion as one of the cases we looked at in March, the case of Mansour by Upper Tribunal Judge Allen. Mr. Ockleton goes on to state at paragraph 14 that there's, and it's paragraph 2 of the head note, that there's no reason, people have been supposing that the figures given initially to the Home Office, which were the higher earning figures in order to get the points in relation to the Tier 1 applications, that they were correct. There's no reason to assume this. It may be the initial lower figures given to HMRC were actually correct. And the fact that somebody's prepared to pay the additional tax doesn't mean the truth was the higher figures. In fact, the truth may be somewhere in between. So we mustn't make that assumption. And thirdly, the point made in the head note is therefore accountant's evidence is essential, building on what the Upper Tribunal said in the Abbasi case, because without accountant's evidence, it may be that the Secretary of State's allegations are established, that there's been dishonesty. In this case, the appeal was successful in that the decision of the first tier was set aside because the first tier tribunal had put the burden of proof in relation to dishonesty on the appellant. But Mr. Ockleton interestingly says at paragraph 20, well, for the rehearing, you'll of course want to call your 2 accountants, and you know how difficult that's going to be. So that's the current position in terms of tax discrepancy cases. Let's move on. BAA is a rather complicated decision in relation to Article 17.2 of the Dublin III regulation. And that's where a member state has a discretion to examine an application for international protection in order to bring together any family relations on humanitarian grounds based on family or cultural considerations. So this was an application by a Syrian national who is an unaccompanied minor, was in Greece, and Greece had made an application to the UK authorities to take responsibility and examine the protection application because the applicant had a cousin with whom he had a close family relationship in the United Kingdom. That had been rejected by the Secretary of State, and they'd initially said it was an invalid request. There had been a number, I think there's 3 decisions in all in this case. Now, the President, Mr. Justice Lane, says, yes, Article 17.2 gives a discretion, a wide discretion on member states. It's not an untrammeled discretion. And he says, as in the case of any other discretionary power of the Secretary of State in the immigration field, Article 7.2 must be exercised in an individual's favour, where to do otherwise would breach the individual's human rights or those of some other person, contrary to Section 6 of the Human Rights Act. Now, he actually quashes all the 3 decisions in this case, finding that they violate ordinary public law principles. See paragraph 2 of the head note. But he also gives a declaration that the Secretary of State's decisions were unlawful and contrary to the appellant's Article 8 rights. What he doesn't do is make a mandatory order in this case. Paragraph 3, where a judicial review challenge involves an allegation of a violation of an ECHR right, such as Article 8, it is now an established principle of domestic UK law that the court or tribunal must make its own assessment of the lawfulness of the decision in human rights terms. If, in order to make that assessment, the court or tribunal needs to make findings of fact, it must do so. So in a human rights Article 8 JR, we're not confined to ordinary JR principles. The court must make its own assessment of the lawfulness of the decision, and they may need to hear evidence and make findings of fact. Look at the judgments of Lord Justice Underhill, both in Karupan and in Balajigari. Paragraph 4, Article 27 and the remedies provision of Dublin III apply equally to Article 17.2, refusals to take charge. Then in Headnote 5, Mr. Justice Lane looks at the investigatory responsibilities and says this: it would be remarkable if the Secretary of State's investigatory responsibilities were materially narrower in an Article 17.2 case, which concerns an unaccompanied minor and his or her best interests, than they would be in respect of any other take charge request under Dublin III. Where the request under 17.2 raises issues that involve an asserted family life within Article 8, Article 7 of the Charter, then in the normal course of events, the Secretary of State's degree of engagement with the relevant United Kingdom local authority should be no less than in the case of any other unaccompanied minor, where the take charge request is made under Article 8 of Dublin III on the basis that the relation in the United Kingdom is a sibling or family member or relative as defined. And Mr. Justice Lane there suggests that the guidance of the Secretary of State may need to be rewritten and amended in the light of this. So there's these duties in terms of local authority and investigatory responsibility in this type of case. Interesting, we've talked a bit about Balajigari today, both in the tax case and in this, but equally, they find that under Article 17.2, there was procedural fairness requirement that an indication or a gist is given to an applicant of matters to concern, a sort of minded to refuse letter, in order for them to make a response to it for procedural fairness. But he does say this is, however, an area where one cannot lay down hard and fast rules, even where Article 8 is in play. There may be exceptions. Furthermore, the process must not become so elaborate so as to defeat the aim of expeditious decision-making, particularly where the best interests of minors are concerned. And then there was a challenge to the guidance and the use of exceptional circumstances. He rejected the challenge that the guidance was unlawful. But a really interesting paragraph in terms of Article 8 generally, he says those working in the immigration field know that the use of exceptional in the context of an Article 8 ECHR is not to be used as setting a particular brackets high threshold, rather as a predictive of the outcome of the application of the principles of proportionality to the facts of a particular case. And he cites Huang in his judgment. Nothing in the guidance suggests its author is telling caseworkers to do anything other than follow the settled law on this topic. Very dense, complicated judgment, probably not something you're going to look at all the time, but if you've got particularly Dublin III and Article 17.2 cases, an important one. DH is very important in terms of remedying a wrong, I think, because in the interpretation of what is a particular social, when somebody's a member of a particular social group, and the problem of Article 10 of the Qualification Directive, and this little word "and." In Article 10, you've got 10.1d.1, where it talks about an innate characteristic. Somebody's got to have an innate characteristic, and they've got to be a perceived member of society, so a distinct societal identity. Now that "and" in Kay and Fauna, Lord Bingham actually said, well, it should be interpreted as an "or." But that was only an obiter comment of Lord Bingham. Now, you might have think, well, it's Lord Bingham in the House of Lords, but the upper tribunal, or the its predecessor, the AIT, in cases such as SB and AZ, refused to follow what Lord Bingham said and said, no, no, it must be an and. So you've got to have the innate characteristic and you've got to be a recognizable group in society. Well, in this very helpful case, Upper Tribunal Judge Hanson says, well, the Geneva Convention provides greater protection and Article 10 should be interpreted with replacing and with an or. So it's an alternative rather than a cumulative test. This was an appellant with serious mental health difficulties, and the tribunal find that a person living with a disability or mental ill health may qualify as a member of a particular social group, either under the innate characteristic limb or because they're perceived different by society. Now, in this case, they weren't able to give the appellant a firm diagnosis because I think the complexity and the severity of his mental health problems, that shouldn't stop somebody coming within a social group, head note 3. Obviously, it's a fact-specific assessment, head note 4, but you've got to look through the eyes of the persecutor, important refugee law principle there, through the eyes of the persecutor, making it possible that those suffering no or a lesser degree of disability or illness may also qualify as a PSG. So it's the perception of the persecutor. And head note 5, they don't follow those previous cases. So a really helpful judgment, merits close reading. So finally, these last two cases on the definition section, really, in 117D. This was an argument about a qualifying child, an Iranian applicant. His protection claim and human rights claim had been rejected by the first-tier tribunal. He had a Polish partner and they had a 3-year-old Polish child. It was argued in the upper tribunal for the first time that the definition of a qualifying child for 117B6, and you know if you've got a genuine subsisting relationship with a qualifying child and it wouldn't be reasonable for that child to leave the United Kingdom, it's not then in the public interest for the person to leave, and it's dispositive of the appeal. They argued that it should be read down as including an EU child because the definition is a British child or a 7-year child. That was rejected by the upper tribunal. The upper tribunal found that the definition does not include an EU child, and it doesn't breach the EU law prohibition against discrimination on grounds of nationality, because the situation there didn't come within the scope of the treaties relying on their Article 18 TFEU. They did find that the first-tier tribunal judge had made some errors of law, both in terms of the assessment of the best interests and in terms that he made findings under the EEA regulations when he had no jurisdiction to do so. But they carry out a balancing exercise and find that the decision is not disproportionate and the public interest outweighs the rights there and the best interests of the child. Finally, a decision in relation to whether somebody with a hospital order can be counted as a foreign criminal. So an individual sentenced to a hospital order, and this is the important bit, following a finding under Section 5(1)(b) of the Criminal Procedure Insanity Act 1964 that he's under a disability and that he did the act or omission charged against him, is neither subject to Section 117C of the 2002 Act as amended, nor paragraphs A 398 to 399 of the immigration rules, because they're excluded by the definition in Section 117D3A and from the immigration rules, because it was sometimes argued, and there's this difference between OLO and ANDL that was finally resolved in SC, that OLO is correct and that the immigration rules must be interpreted consistently with the statute, Section 117A to D. So in this case, they were excluded from the deportation provisions, and the upper tribunal upheld the decision of the first-tier tribunal, allowing the appeal. So I've rattled through those at speed, some really deep and complicated issues, but some really helpful decisions, particularly the one on particular social group and some important decisions in June 2020. I'll put the links below. I'll put the PowerPoint on the website, but I hope that's helpful to you, and we'll be back with the July decisions soon. Thanks a lot.